Welcome back to BLOCKTV. It's time now for Links in the Chain, where we get a chance to speak one-on-one with blockchain industry experts. And today, we've got a chance to sit down with Stephen Palley, partner at corporate law firm Anderson Kill, to help us break down some of the latest legal and regulatory moves coming from the US. Stephen, thanks so much for joining us.
Glad to be here. Good morning, or good afternoon, I suppose.
Wherever you are in the world, good morning, good afternoon, good evening. But, Stephen, let's kick things off talking, of course, about Kik and the SEC. Now, Kik has just launched back with over a 100-page report using some pretty aggressive language against the SEC's push to prosecute them against their ICO launch back in the peak of the crypto bull run of 2017. What do you make of this report? It's come very strong, very aggressive, over 100 pages. It's a very intense document. What do you make of it?
Well, it's not a report, it's an answer. So for those folks who are listening outside of the United States, in a lawsuit, you've got a complaint in federal court, which is what the SEC filed. And a complaint usually says bad things about the other side. And you're not going to sue somebody if you think that they're okay or that you agree with them. So the SEC filed a very long complaint with lots of details, contending that the KIN token sale was an unregistered securities offering, and it read badly. It said a lot of things that I'm sure the folks at Kik were very upset about, and Kik answered. It's not a report, it's an answer. Kik filed an answer to the complaint last week, and the answer obviously took a very different position. Kik accused the SEC of twisting facts, taking quotations out of context, and generally speaking, accused them of, being up to no good. And the other part of your question was, what did I make of that? Well, first I should say, while it is over 100 pages long, a good part of the reason for the length is that it includes the allegations in the SEC's complaint, which was, if I recall correctly, over 50 pages. So some of that length is attributable to the fact that it's repeating what the SEC said and then providing an answer underneath. As far as the tone, if you back somebody into a corner, I suppose it's not surprising that they're going to respond aggressively. That's the way I took it. I'm not sure that calling the SEC liars is certainly not going to do anything to get this case closer to settlement or resolution. The SEC has been around for a long time. It's likely to stay around. So I think what Kik has done by the tone of its response is to send the message that it's prepared to fight. I don't really think that that will intimidate the SEC, but I suspect we're going to be seeing more filings for the foreseeable future.
And certainly, and I suppose I want to ask as well, from a legal standpoint, now Kik attempted to create this Defend Crypto fund, sort of create this into a larger scale issue about setting precedent for the crypto community in the United States and for further ICOs and other such offerings into the future with the SEC. Do you think that the way it seems to be heading so far, and perhaps it might be too early to tell, but if not, do you think that this is lining up to be that sort of precedent-setting case that Kik had hoped it would be, or will this just be related specifically to this specific token offering?
Well, every case has the possibility to set precedent. You never know what the precedent will be. One of the things that Kik has said, and it said this in its, it filed a response, it basically filed something with the regulator, a Wells response, in which it tried to explain why it shouldn't be held liable. And one of the things that it said was that the Howey test, the Supreme Court's opinion in Howey, was outdated and that US securities laws would be outdated, and they've said that they would take this all the way up to the Supreme Court and ask the Supreme Court to change the law as it relates to securities in the crypto space. I am skeptical that that will happen. I'm skeptical that we will see useful, well, I don't know about, maybe the word useful is incorrect. I'm skeptical that we'll see precedent that vastly changes securities laws. or that gives blockchain or crypto sort of a special exception, if you will, or special treatment. I don't think that will happen. I think that the rulings about this particular token sale and whether it is or isn't a security will be mostly applicable to this case.
It'll be interesting to see how that one pans out, and something we'll have to follow closely. But while we're speaking of the SEC, let's deal with another element of the crypto sphere that they're coming up against. That, of course, being the ETFs. 3 potential ETFs that they've delayed making a formal decision on yet again. But they will be coming up, buttressing that legally mandated 240-day period in which they will have to make a final decision for Bitwise, VanEck, SolidX, and Wilshire Phoenix all around end of September, mid-October. What do you make of this decision to delay? I suppose it was largely expected, but do you think we'll be seeing the sort of decision the industry would hope for come October?
Boy, I hate to make predictions. My sense is that there is concern within the commission about the, what's the word that I'm looking for, about the security or predictability of the underlying asset. I mean, we're still dealing with an asset class that will go up or down 10 or 20% in a day. And I think the SEC still has questions about that. So I'm not making any predictions, and I don't have any inside information into the SEC's thinking. If I did, of course, I wouldn't be able to share it, but I don't. I would be surprised if we saw an approval this year. I think it will happen eventually, but based solely on public statements that we've heard to date, I don't think it's likely to happen. I'm not saying that's a good thing or a bad thing. I don't think it's going to happen anytime soon. I think there's still too many unanswered questions in the SEC's mind.
Certainly there do seem to be a lot of unanswered questions, but in terms of answering those questions now, Bitwise in particular has made stringent efforts, releasing a series of different reports talking about legitimacy of the industry, the trade volumes that are taking place, the stability in the industry. Obviously, that volatility issue still of major concern, but what with Bitwise releasing their reports, among others, with increased sentiment and awareness, particularly on Capitol Hill and elsewhere in the higher realms of Washington elites, do you think that there's any chance that perhaps that could help set up a different landscape to maybe sway decisions in a different way, or is there still just too much work to be done in your opinion?
It seems like it's still kind of early days. I understand the eagerness in the industry for this to happen, and it would certainly be good for many of my friends and clients if it did. But by the same token, I think if you're the SEC and you've been around for a long time, your question might be, why can't we wait a year or 2 years or even 5 years? Let's make sure that we have proper market surveillance tools in place. Let's make sure that we understand custody and we understand security. Let's make sure that we're prepared to get things right before we allow these instruments to trade. That's a question I would ask, is why not wait another year? Literally, how much has Bitcoin gone up this year?
Well over 100%.
In March, yeah. $4,000 in March. It's what, 11 or 12 grand today? I don't follow the price.
Sitting at just above 11,000 right now.
Yeah, it's. I suppose volatility in and of itself is not an argument against approval of an ETF, but I think that there are, in the eyes of a very conservative regulator who has to think about market stability writ large for the entire country, I think there are some legitimate questions that have to be asked and answered. And the response, a fair response from someone whose job is to protect the market and to protect market participants is, why can't this wait a year? Let's get some more questions answered first.
Okay, so a call for a bit of patience, maybe something that those in the cryptosphere aren't necessarily known for, but as you say, maybe a bit of time, a bit of patience, a bit of proof of fidelity might go a long way when it comes to the SEC. Now to a story that I would argue flew a little bit under the radar a bit. We can discuss Coinbase, which is now being sued for negligence in regards to their rollout of Bitcoin Cash. back in 2017, said that Coinbase didn't do their due diligence, and potentially even some are arguing there was some market manipulation going on, and some have even said insider trading. What are your thoughts on this?
Well, it's a really interesting case. It's Burke versus Coinbase. It's a case out of the Northern District of California. In addition to a very active law practice, I also write and contribute to the Block Crypto, which is not associated with BLOCKTV, but also has the name Block in its brand and title. I wrote a piece on it if folks are interested that goes into greater detail about the significance of the case late last week. But it's interesting because one of the things that the court said was that Coinbase has a duty to provide for a functional market as a crypto exchange. And that's very interesting because in the US and I suppose in other common law countries as well, you've got basically two buckets of obligations that you can have to folks. You can either, in the civil context, you can either be liable to somebody for breach of contract, you enter into a commercial agreement with them, or you can have a tort obligation to them. So the difference might be if I pay you to cut my grass and you do a bad job, I can't sue you for negligently cutting my grass. I can only sue you for breach of contract. It's sort of a basic fundamental principle in US law. On the other hand, if while you're cutting my grass, or if on the way to cutting my grass, your truck runs over my cat or my shrubs, I can sue you for negligence because that's something outside of the contract. Even though we didn't have a commercial relationship, you've got a duty to me. So anyway, what does that all have to do with Coinbase, you asked? The court said was that even though there was a user agreement, terms of service between Coinbase and the plaintiff in this particular case, the court said we are still going to find that there's an obligation to maintain a functional marketplace, which is outside of the realm of contract. So it's not like you're actually suing for negligent performance of a contract. There's this other external obligation. And I think that that's interesting from, it's not entirely new law if you look at contract and tort law generally speaking, but it's the first time that a US court has said that a crypto exchange has a duty in tort to maintain a functional marketplace. And if you look at some of the problems that we've seen on exchanges in the last couple of years, flash crashes, alleged spoofing, market manipulation, what it shows that even though you may have terms of service that purport to limit an exchange's liability to its users, there may be other additional obligations outside of the realm of contract that these exchanges can be subject to. So as a lawyer, it's very interesting. And also as a consumer, if you follow what I just said, and I hope I made it non-lawyer-ish enough, you see that exchanges may have duties to you that extend beyond sort of the four corners of the terms of service. And I think that's, I think it's important to understand.
But I suppose I kind of wonder, in a new industry like this, I mean, obviously this is still an exchange in the classic sense. They are still trying to establish a marketplace. But given it is such a new asset class and dealing with functional and technical issues that haven't necessarily been dealt with before, does that give some sort of leeway, do you think? Or do you think it's likely to give some sort of leeway to these exchanges?
Absolutely not. No way. I think the argument that we launched a marketplace and it's new and so we don't understand it, so we get a free pass to maybe lose your money, that will never fly. The answer is, if you can't do this safely and securely, maybe don't do it. I think that's the answer. Certainly they made plenty of money. The notion that they can make plenty of money using a new technology but not be responsible for loss or risk is not a good argument. It's certainly not one that I would make. I'm not saying, by the way, that I agree or disagree with the court's ruling, and I should also note that it's interesting enough law, and in a kind of a difficult legal space that it's probably going to appeal, and it's possible it could be reversed on appeal. But nonetheless, to your question, do you get a free pass because the technology is new? In this context, I would say probably no.
And in terms of ever seeing sort of similar prosecution outside the United States, obviously Coinbase attempts to be compliant with in the US jurisdiction, but other exchanges, for perhaps this exact reason, choose to establish themselves outside the United States. Do you think there's any likelihood of similar action being taken against those organizations, or do you think this will have to stay with Coinbase and other compliant US exchanges?
So from a terminology standpoint, just to clarify, prosecution, when I hear prosecution, I think of criminal liability. This is not a criminal prosecution. This is a civil lawsuit brought by private individuals against Coinbase. I'm obviously not a lawyer in any other country other than the United States, so I can't speak to liability outside the United States. I think this general principle that you have contract liability and you have tort liability is not something that's restricted to the U.S. I don't know that. I don't know what will happen in other countries necessarily. I do know that not just in crypto, but in other areas and other verticals, people worry about the United States because of our court system. Or one of the, I think the only country in the world where there are jury trials in civil cases. So on the one hand, the U.S. is a major market with a lot of opportunity. On the other hand, we do have a court system that creates risk for people. So I think there's a little bit of there's a risk-benefit analysis. Do you want to access the U.S. market, which I think is, it's a great place to do business? Is the trade-off with having to deal with our court system and our regulators worth it? I don't know. That's a decision every business has to make on their own, I think.
It's certainly a decision for those in the crypto sphere are having to come to terms with. Do you try and access that US market and risk facing those stiff regulations? All right, well, Stephen, I want to thank you so much for joining us here on BLOCKTV and helping to break down some of these tough legal and regulatory issues for us. And please stay with us at blocktv.com for all the latest in news, analysis, and information. I'm Westropp Evans. Thanks for watching.
For more news and updates, follow us on Twitter.